Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Klossing.
Okay, if you've just faced an audit, this video may be important to you. It's on what are the basics of IRS Appeals representation. What do you need to know if the IRS is taking a position that you don't agree with? You don't think they got the law right, you don't think they got the facts right. Bottom line is they're talking more tax, penalties and interest, and you don't want to be on the hook for those amounts. Let me tell you this, if you do nothing, if you just stall and ignore all their communication, what's going to happen is they're eventually going to issue what's called the statutory notice of deficiency, which is a 90-day letter. If that 90-day period ticks and you take no action, even if they got the law wrong, they got the facts wrong, the amount thereafter of tax, penalties, and interest becomes legally accessible and collectible, and you're on the hook for it, even if they completely in left field with what they did. Okay, so this video is on how you go about contesting an IRS assessment, or a collection action for that matter. When the auditing process concludes, the IRS will send you a notification letter explaining its findings and any changes they propose to bring you back into its version of what your tax compliance should have looked like. The first step, even before you get a 30-day letter or a 90-day letter, ordinarily the auditor will communicate with you his or her findings, and if you disagree, the first opportunity you get to chime in with your opinion is by scheduling an informal meeting between the auditor and their manager where you argue why the facts are different or the law is different and why they shouldn't have assessed you additional tax, penalties, and interest. Best to do this with a representative. If following this informal meeting you still disagree, you should consider formally appealing the IRS's assessment, and that's what this video is on. How do you do that? On the other hand, if you agree with the changes the auditor is making, all you have to do is sign off on their auditor's report. At that point, you give up all appeal rights. The amount becomes legally assessed, and they can begin collection action on you to collect those amounts the next day. So be very careful. See a tax professional before you sign off on an audit. The cold, hard truth here is that the appeals process is not for amateurs. You really need to have someone take you through that process that understands it well and has a track record of getting good results for the clients they take through it. Unfortunately, if you don't get what you're looking for in the appeals process with the IRS Office of Appeals, you may have to take your case on to tax court and actually litigate it. A good tax attorney can often still negotiate a settlement with the Office of Chief Counsel after appeals washes their hands of the issue, and you might not necessarily have to incur the cost of litigation if the facts are on your side and the law is on your side. Working with an experienced attorney CPA can help you maximize your chances of making a successful appeal, while at the same time resolving your tax liability as efficiently and cost effectively as possible. How do you as a taxpayer know when you're ready to take a case to appeals? What should you be thinking about? Well, it comes down to this. Did the IRS get the facts right? Did they get the law right? If they're wrong on either account, they could have reached an improper legal conclusion and unfairly assessed you with tax, penalties, and interest. Actually, it's my job to fairly assess whether you could potentially benefit from filing an appeal, and I always do a cost-benefit analysis. The cost of bringing the appeal versus the potential decrease in tax, penalties, and interest. I will rarely bring up an appeal unless I think you're going to be better off financially fighting the issue. And I'm the first one to tell you whether I think you've got a case or not. Bottom line is this: you're in a position to appeal when you can persuasively and eloquently make your case as to why the IRS is wrong and you're right. As I said before, valid grounds for an appeal is where you can disagree with the IRS's findings because they misapplied the law, they're misapplying the underlying facts, and therefore taking an improper position. If you need help in deciding whether you should bring an appeal or not, run your case by a professional such as myself. There are lots of good tax attorneys out there. My job is to eloquently make a legal case in writing why you should prevail. What is the case law that I'm relying on? What's the Internal Revenue Code that I'm relying on? What is the persuasive authority, primary authority that I'm relying on to give them basis in the law that's on your side? And which facts am I pointing to that say I should get the legal result of that primary authority? An appeal may also be proper when you think the IRS is unlawfully collecting from you, taking some sort of collection action that you disagree with. As in when they deny your reasonable offer and compromise, when they deny your reasonable installment agreement offer. If this is your situation, you'd be wisely served to hire effective and persuasive tax counsel to argue your case. So what types of IRS collection actions can be appealed? Well, the answer here is almost any type of collection action can be appealed, including rejection of an offer and compromise, rejection of an installment agreement, the improper assessment of a trust fund recovery penalty, an improper denial to abate penalties, late payment filing, or deposit penalties. Okay, why should you hire specifically a tax attorney to argue your appeal? Well, first of all, if you've gone through your audit with the original preparer, whether that be a CPA, an EA, or maybe even a tax attorney, and you believe that the law is on your side and the facts are on your side, and that representative hasn't been able to persuade the IRS auditor to your position, chances are they're not the most effective advocate to begin with. Maybe you should be shopping. I can tell you this, representing yourself without a tax representative in front of the appeals division is a patently bad idea. Let me explain why. To do so is akin to representing yourself in a court of law, going into a court of law without an attorney pro se. Not a good idea there either. You'll be at a distinct disadvantage because you're not trained in tax law and you're also not familiar with IRS procedure. It's imperative that you have an expert representative by your side to protect your rights. Over 80% of the disputes faced by appeals are settled through appeals. The odds are on your side that if the law is on your side and the facts are on your side, if you have a persuasive, competent legal representative, they'll be able to bring appeals over to your point of view. Most of all, it's imperative that you hire somebody that understands the ins and outs of the appeals process, someone that has lots of experience. I can tell you this, I've sued the government about 50 times in the past 7 years. I have settled every single lawsuit I've ever brought against them, either through the appeals process itself. If I can't get the satisfaction I'm looking for there, then with the next step in the process, which is in front of Chief Counsel's office, sometimes on the courthouse steps. Most of the time where small dollars are at issue, it doesn't make economic sense to push a case all the way into tax court. You need somebody that can resolve it before you get there. You need to understand that the IRS handles hundreds of thousands of appeals on an annual basis. If you try and deal with this yourself, you're going to have the experience of one appeal, and that'll be after you've completed it. You'll be at a distinct disadvantage. Why specifically would you might want to consider the tax law offices of David W. Clausing as a great choice to argue your appeal? I can tell you this, I'm an assertive, seasoned, and knowledgeable tax attorney CPA. I have lots of experience in the appeals process. I believe I can make an enormous difference in the type of settlement that you receive at the conclusion of your appeal. Here's a dirty little secret. Like yourself, the IRS would like to avoid the cost, expense, and hassle of litigation, just like you. It's also high stakes for the government. If the government loses a case that actually gets litigated, that's public record, and it may set a very costly precedent to the government in future cases going forward. Having a seasoned, experienced tax attorney CPA on your side increases the government's observations of the hazards of litigation. Let me explain. When you take your case to appeals, what you're basically saying to the government is, I'm willing to litigate this issue. Now, what they're supposed to do is weigh the hazards of litigation in determining whether to settle with you. If that appeals officer believes he has a 50% chance of that case being won, if it actually gets litigated. He may be willing to write off 50% of the proposed taxes and interest currently assessed against you. When you bring someone to the table, like me, that's the ex-California State Bar chair of the Tax Procedure Litigation Committee, and just itching to get their litigation experience, because frankly, 98% of all issues settle without litigation, I'd love to litigate. They know that when I bring your case, they know that I'm dying to get the chance to litigate. Your representative's job is to get the IRS to realize the perceived hazards of litigation and get them motivated to settle the matter to avoid the courtroom altogether. If you hire my firm, a tax controversy firm, you get the experience of myself, and I have a team of tax attorneys and CPAs on board that have the experience, training, and education to vigorously represent you in front of the IRS. I alone, by myself, have over 20 years of tax controversy experience. I will personally make sure that your case is well prepared and well represented in front of the Appeals Division. My firm will assist you in collecting and organizing your documentation, your books, your records. We'll make sure whatever research needs to be done to support your positions is accurately documented. We'll document the tax law that we're relying on that says why you should win, why the government should lose. We will come up with counter arguments to any position that they're attacking you on, if there are any. We will aggressively present your case to the IRS Appeals officer and zealously negotiate any advantages in a settlement that are possible to obtain. Over my 20-year career, I have successfully defended many individuals, corporations, partnerships, trusts, and estates, all of which found themselves in the line of fire of the IRS. I kind of alluded to this earlier, but why might you want to ditch your original preparer or original representative when you head into the Appeals Division? First of all, there's mainly two ways to get into an appeal. One is to request an appeal by writing a protest letter during the 30-day period if the government starts off by giving you a 30-day notice. If the government skips this step and goes right to a 90-day notice, you must file a tax court petition to get into appeals. If your CPA prepares a tax court petition, they could get charged with the unauthorized practice of law. They shouldn't be doing it. But to tell you the truth, I've seen it done a lot. What they normally do is they write it up as if you filed it, and they have you representing yourself pro se before the government, banking on the fact they can settle your case in the appeals process without having to litigate. Well, I can tell you this, one of the main reasons I went to law school is as a CPA in the appeals process when I said, you know what, if you don't give us the settlement we're looking for, if you don't treat us correctly, if you don't get the law right, if you don't get the facts right, we're going to litigate. You know what I got back? The appeals officer laughing in my face saying, you're not going to bring anything to tax court. You're out. Taxpayers going to have to go out and hire a tax attorney. Also, one of the most effective ways of getting out of penalties and the associated interest on those penalties is to argue that you reasonably relied on a professional in taking a position that the government burned you down on. Well, the original preparer is not very likely to throw himself under that bus. It's a great reason to hire someone else. This situation creates a potential conflict of interest between you and the original preparer. Your interests are at odds with the original preparer. Your interest is to reduce the tax penalties and interest that come out of this case. Their interest is in preserving their reputation with the taxing authorities. That's why they're not likely to throw themselves under that bus to get you penalty abatement. Also, if they make the admission that they were negligent to get you out of penalties, that is sufficient for you to sue them for negligence, and they're not likely to throw themselves under that bus for that reason as well. No such conflict of interest exists when you hire a tax attorney to represent you, especially when they didn't prepare the original return. What is the most important thing for taxpayers to know about the IRS appeals process? Well, I've said it before, I'll say it again. If you allow the 90-day period to lapse without filing a tax court petition, even if the IRS doesn't have the facts right, they don't have the law right, their assessment becomes legally collectible and they can go straight to collection action. Moreover, the only way to get them to take another look at the issue is through a process called audit reconsideration, and this is not mandatory. This is optional on the part of the IRS. A lot of times when you ask for it, you'll hear no. The most important thing I can tell you is if a 90-day letter is running on your issue, please contact me as early as possible in that process so I have sufficient time to weigh the facts and the law in your case and determine whether an appeal is a good option for you or not. Frankly, if my legal fees make your situation worse, if I can't better you by reducing the tax liability by more than it costs you to fight the appeal, then it doesn't make economic sense to fight the appeal, and I will not recommend you fight an appeal in that situation. But I will tell you this, that's a matter of judgment and no guarantees can ever be made. When is the filing of an appeal inappropriate? Well, if your only concern is that you can't afford to pay the taxes that are due, along with the penalties and interest, and your desire is to delay the collection action of the IRS, that could be considered a felony, tax evasion. That's inappropriate to bring litigation in that situation. It's also inappropriate if the only communication you got from the IRS was a bill that they're trying to collect on. An appeal is probably not proper in that situation unless it's a collection due process appeal. So what's the exact function of the IRS Appeals Office? Appeals is the IRS Appeals function of the IRS. First of all, the Appeals Office is supposed to be separate, distinct, and independent of the IRS examiner and their manager who are proceeding against you. And you need to know that the Appeals Office is the only administrative level of appeal within the IRS. The Appeals Office works with taxpayers informally. Their goal is to avoid litigation between the IRS and the taxpayer. Their job is to consider the positions taken by both the IRS and by the taxpayer in reaching a fair resolution to the dispute, while at the same time attempting to remain impartial to both parties, the taxpayer and the IRS. So, what protections exist to guarantee that the Appeals Office is truly independent? Well, Appeals is supposed to vigorously protect your right to a fresh and independent look at your case. As Appeals considers your case, ex parte communications between the Appeals Department and the IRS agent and their manager that are moving against you are prohibited. You're supposed to be in the room when Appeals is talking to the IRS agent and their manager. What this means is there's not supposed to be any communication between the Appeals Office and the IRS agent and their manager attempting to assess additional tax penalties and interest, discussing the strengths and weaknesses in your case without you or your representative being in that room. There's actual Internal Revenue Code law drafted around prohibiting this ex parte communication. It's designed to protect your fresh and independent look at the case afterward. So what are the main advantages in filing an appeal in the first place? Why should you consider one? All told, according to the IRS's own internal statistics, taxpayers are ordinarily 40% better off following an appeal than they were going into it. IRS appeals officers are hired to settle cases. They are not evaluated by how much revenue they generate. They are evaluated by how quickly and effectively they fairly settle tax disputes between the IRS and taxpayers. IRS internal statistics also show that 70% of the appeals are settled in a way that is acceptable to the taxpayer. And again, the main advantage of filing an appeal is your opportunity to settle a case without incurring the expense and the hassle of tax court litigation. One big advantage of filing an appeal is that it gives the taxpayer and their representative an informal communication, an opportunity to discuss and negotiate a case informally with the appeals officer rather than in the strict adversarial arena of a docketed case in tax court. Moreover, the rules of evidence that apply in tax court are not adhered to in the informal appeals process. Taxpayers may even be able to get information in front of the appeals officer that would be formally inadmissible at a tax court trial. For example, affidavits and documentation may be submitted in lieu of live, often expensive testimony of witnesses who would be subject to cross-examination at trial in front of an appeals officer. For example, rather than putting on expensive testimony of expert witnesses in front of a tax court, you could informally put forth affidavits and documentation of experts without having to have that expert cross-examined by an expert at trial. Also, requesting an appeals conference preserves the taxpayer's right to the reasonable costs of litigation if you prevail later on at tax court. The appeals process also delays payment of the tax at issue, collection and payment. Promise me you won't file an appeal just to delay. I won't be representing you if that's your reason. The IRS will also delay issuing a notice of deficiency in a case. In other words, you got into appeals off of a 30-day letter and a protest rather than filing a notice of deficiency. But there has to be sufficient time remaining on the statute of limitations before they'll hold off on issuing the 90-day letter. How do I formally start the IRS tax appeal process? Well, depending on what your issue is. A tax appeal can be initiated in three ways. The first way is to write a protest letter following an IRS audit, ordinarily during that 30-day period if they issue a 30-day letter. The second way is to file some sort of a formal protest to a proposed IRS collection action, such as a tax lien or levy. The third way is by filing a formal tax court petition. What will happen if you formally appeal your case? Normally, if you're appealing some sort of a collection action, the IRS will halt their collection action while they're considering your appeal. So if there's a lien, levy, or a seizure at issue, they won't follow through with those actions until your appeal is finalized. Once you get a tax period into appeals, collection action halts while they consider your appeal, unless the IRS believes that collection of tax is at risk. Then they might ignore your appeal. How long will it be until the IRS hears your protest or your appeal? The appeals office response time varies depending on the type of case you're appealing and the time needed because of the complexity of the issues that you're raising in your appeal. Normally though, you can at least expect to hear from the IRS Appeals Division within 90 days of filing your appeal to let you know that they're accepting your case and that they will be looking at it. How do I successfully protest an IRS audit decision? Well, this is, again, if you received a 30-day letter and you're writing a protest to an audit, this is what needs to be included in that protest. A statement that the taxpayer desires to appeal the findings of the IRS to the appeals office. It must include the taxpayer's name, mailing address, and daytime phone number. You must include with your protest letter a copy of some correspondence from the IRS that speaks to the action that you're appealing. If it's an audit, the IRS audit report. If it's a collection action, the proposed collection alternative that they are bringing against you. You must include that correspondence with your protest. You must specifically list out what it is about that correspondence that you disagree with and wish to contest. You must specifically address the tax periods at issue. You must provide a statement of facts, which are the facts that you're relying on that should get you a different legal result than the IRS is proposing. You must include a statement of the law that you're relying on, a list of the primary authorities that gives you the legal grounds for the position you're taking. The taxpayer is required to swear under penalties of perjury that the facts as you're stating in that correspondence are true, accurate, and complete. Matter of fact, the following jurat must be used. Under penalties of perjury, I declare that I have examined the statement of facts stated in this protest and in any accompanying documents, and to the best of my knowledge and belief, they are true, correct, and complete. What you need to understand is that your protest letter needs to counter the revenue agent's report and show that the IRS's litigation of the issues in your case are either inappropriate or hazardous to the IRS. The detailed factual statement and legal arguments made in your protest should indicate whether the revenue agent has failed to set out facts accurately, or rather has failed to consider necessary facts to reach a proper legal conclusion. Where necessary, the factual statements in your protest should be supported with documentation, affidavits, and statements of potential witnesses. From my perspective as a tax attorney, I can tell you that the most effective protest letters demonstrate immediately to the appeals officer that reads them that my firm, myself, has a firm grasp on the facts, has a firm grasp on the law at issue, and most importantly, that we're ready to proceed to trial if necessary to defend our position. One advantage to the taxpayer in writing a protest letter is that the attachments to the protest letter do not have to conform to the rules of evidence at this stage of the case. I can tell you this, unnecessary information contained in a protest letter may backfire in that it may give rise to new issues that come up in the appeal that were never discussed in the original audit. Your representative, therefore, should not make a haphazard submission of documents along with your protest, but rather should carefully review each document before submitting it to avoid the possibility that new issues surface in the appeals process. In some circumstances, your representative may feel that you're better off providing excerpts of documents rather than the entire document. Take a board of directors meetings minutes, for example. If a protest fails to set forth the taxpayer's position, lacks substantive detail, or is otherwise seriously deficient, appeals may return the case to the original office where the examination took place for a redetermination of the disputed items raised in your protest, with or without a recommendation to proceed to assessment, in an attempt to make the amounts owed on the original assessment permanent. What happens if you get a 30-day letter, you protest the 30-day letter, and you still can't reach an agreement with the Office of Appeals? In most instances, you'll be eligible to take your case to tax court if you don't reach an agreement at your appeals conference. Or rather, if you don't want to appeal your case to IRS Office of Appeals at all, you can still go straight to tax court. If your disagreement with the IRS is over whether you owe additional income tax, estate tax, gift taxes, certain excise taxes, or penalties related to any of these proposed liabilities, you can go directly to United States Tax Court without going first to appeals. However, this is only possible after the IRS first issues a notice of deficiency or a 90-day letter. Ordinarily, you'll have 90 days from the date of this notice of deficiency in which time to file a tax court petition to get into tax court. Or if your address is outside the United States, you have 150 days from the date that 90-day letter was written. Be sure to take notice of the last day in which you can file your tax court petition, which is clearly delineated on the notice of deficiency. But beware, if you don't file a tax court petition within that 90-day period, the amounts owed on that notice of deficiency will become legally assessed even if the IRS is completely out to lunch in reaching that assessment, after which time you will start receiving bills. If you don't choose to go to appeals after receiving the 30-day letter, ordinarily you'll have a chance to go to appeals after filing your tax court petition. You may be able to recover your reasonable litigation and administrative costs if you're the prevailing party at tax court. However, you must meet certain requirements, including that you must exhaust your administrative remedies before reaching tax court. The only way for the tax court to deem that you have exhausted your administrative remedies is for you to have participated in the appeals conference before reaching tax court. This also requires you to give reasonable extensions of time where requested by the appeals office to give them the necessary time to review the facts and circumstances of your case. Lastly, the taxpayer must not unreasonably delay the administrative or court proceedings. Administrative costs include costs incurred on or after the date you received the appeals decision letter, the date of the first letter of proposed deficiency, or the date of the notice of deficiency, whichever occurs earlier. Attorney's fees that generally don't exceed $125 an hour, indexed for inflation, are generally recoverable. Amounts in excess of $125 an hour are not. The reasonable expenses of expert witnesses, the cost of studies, analysis, tests, or engineering reports that are necessary to prepare your case for trial may also be recoverable. So, what are the inherent risks in taking your case to the appeals office? The first thing I need to tell you is that an administrative appeal is not risk-free by any means. It is entirely possible that in the appeals process, the government can generate even more support for the revenue agent's audit report, or perhaps even raise new issues in the appeals process. Appeals officers are, however, instructed not to raise new issues unless the new issues are material and likely to have a substantial effect on the underlying tax liability. New issues are not supposed to be raised in the appeals process as a bargaining chip. Nevertheless, in my experience, it's much more likely for appeals to raise a new issue than it is for that new issue to crop up when you're in front of Chief Counsel's office. If the appeals officer does raise a new issue in the appeals process, when you get to tax court, the burden of proof will be on the IRS as to that new issue. What can you expect from the appeals office? The appeals office is supposed to be independent of any other IRS office and is supposed to provide a venue where disagreements concerning the application of tax law or fact can be resolved on a fair and impartial basis for both the taxpayer and the government. An appeals officer will review the strengths and weaknesses in your case and give it a fresh look. Appeals conferences are concluded in an informal manner by written correspondence, by telephone, or in person. I have found the best results are always obtained in person. And the good news here is that most differences between the auditor and the client are settled in the appeals process without the expense and time-consuming efforts it takes to litigate. What does the IRS Appeals Office expect from taxpayers? Taxpayers have the following responsibilities when dealing with appeals. At the outset of the appeals conference, taxpayers are expected to listen to the appeals officer's explanation of the appeals process and the taxpayer's rights within that process. You, or more likely your representative, is expected to provide a clear explanation as to the law and facts on which you're relying and where you disagree with the IRS's audit assessment. You are expected to provide any additional information that will help your case within a reasonable time. You are expected to clearly tell them when and how you think your case should be resolved. You're also expected to provide them with the best time for them to contact you or your representative. How is the IRS Office of Appeals required to treat taxpayers? The Appeals Office makes the following commitments: to explain to you your appeal rights and the appeals process, to listen to your concerns, be courteous and professional, to be timely and responsive, to be fair and impartial. How does the appeals process ordinarily conclude? In my experience, the appeals process ordinarily best concludes when a mutually agreed upon settlement position is reached that takes place in a face-to-face meeting with the appeals officer, and that is reached on the spot. The appeals officer will then proceed to complete form number 870, which is a consent to a proposed assessment which both parties sign. But be forewarned, once you sign the form 870, you agree to pay the amount of the settlement, and you're prohibited from subsequently challenging any of the included settlement terms in tax court. If you feel the Form 870 was prepared in error or doesn't include the terms you thought you agreed to, simply don't sign it. You can then either try and reach an acceptable settlement with the Office of Chief Counsel, which follows on the heels of appeals, or go on to litigate your issue in tax court. Do interest and penalties stop while the appeal is pending? Interest and certain penalties will continue to accrue during the appeals process and during any subsequent tax court litigation on any amount remaining unpaid. For this reason, you might want to post up a bond as to the amount in dispute, which will stop the running of interest while you litigate. Interest begins running from the due date of the return at issue. The IRS has 3 years from the filing date of that original return to adjust any amount they believe to be due. Again, a taxpayer can stop the running of interest by simply paying the amount at issue and suing for a refund, which I don't believe is a good idea in most cases, because it's even harder to get your money back than to stop from having to pay it in the first place, or by putting a deposit down for the amount of the dispute. A deposit stops the running of interest but does not deny the tax court jurisdiction over your case. You need to know that if you make a deposit and you prevail later on in tax court or in the appeal, you're not going to get paid interest on the amount of the deposit while they have your money. Well, thank you very much for watching this video. If you have any questions, or if you want to determine whether it makes logical sense for you to contest an IRS assessment through the appeals process, or by going to tax court, I'm more than happy to answer those type of questions. Thank you.
Thank you so much again for your time and interest in how we may be able to help you. Please don't hesitate to call if something is worrying you. We would be very happy to help. Just call or email for a reduced rate consultation.